Today is Wednesday, August 15, 2012, and we're here at the beautiful Hyatt Regency in Maui. My name is Victor Gold, and we're going to be interviewing today Judge William Canby in a brief oral history to record some of your reflections, Judge, on your career in the law. I'm here on behalf of the Ninth Judicial Circuit Historical Society, and this interview will be preserved in their archives, and the Historical Society will provide you with a copy for your own use. So why don't we begin by having you talk a little bit about why did you decide to go to law school? Why did you want to be a lawyer?
Well, I can't look back to any, great familial influences or anything like that. My father never went to college. My mother went 3 years and quit because she said she couldn't stand the streetcar ride. And we didn't have any lawyers in the family. We had one family friend who was a lawyer, but I didn't have much contact with him. When I was finishing college, I'd been in the Air Force ROTC and was expected to go on active duty. And I graduated just as the Korean War had ended, and the services were having a little indigestion, so they came out with a thing and said, if you want a delay to go to any of 3 different kinds of graduate schools, one was law, you can delay your active service and go to law school. And I thought, well, all right. I was finishing at Yale, and I thought, well, I can go to law school at Minnesota. In those days, you could apply for law school in July and enter in September.
Yeah.
And so I decided on law, and it was not a matter of long reflection, and it was as late as April of my senior year in college. Then when I got to Minnesota, I found I really liked it. Law was really intriguing to me, a great mixture of history and policy, and it was just, I really liked it, and so went through law school, liked that very much. Then I did go in the Air Force and was in the Judge Advocate department for a couple of years, and I got a letter from my dean, my former dean, Bill Lockhart at Minnesota, saying, I'd like to put your name in with Justice Whitaker for a clerkship in the Supreme Court. And I got the letter, and I thought, well, gee, do I want to do that? I thought about it for a couple of days and talked to somebody who knew something about it. And so I said, well, all right, yeah, if you want to suggest me, that's fine. I'll go ahead. I'm finished, I'm done with active service, and after my 2 years are up. And so I hooked a ride on a plane that was going for an overhaul. I was in Washington State, in McChord Air Force Base, and flew to New Jersey, went down to Washington and had an interview with Justice Whitaker, and they basically hired me. That was a few months before I got out and went to Washington. There again, in those days, justices, I think Justice Souter did this all along in later years, but Justice Whitaker would maybe interview around Thanksgiving for next July's clerks coming in. He tended to try to get people who had some connection with the Eighth Circuit, which was his circuit, and that helped me, I think. But that was a great experience, and it would have been, it's kind of horrifying to me to think back that I actually contemplated whether I'd want to do that or not, because it was just an absolutely unmatched opportunity. In some ways, I think it was probably the best preparation for being a circuit judge, too.
So were there members of the court then that were role models for you later when you joined the circuit court?
Yes, and they were all a little bit different. And the clerks, when I was a law clerk, the clerks every 2 weeks, we all ate in the cafeteria downstairs in the Supreme Court, and we had a separate room for the law clerks, and so you'd go through the cafeteria line and then bring your meal in, and we'd all sit together. And every 2 weeks we'd bring a speaker in, and during the course of the year, each justice came in and spoke to the clerks and everything, and it was a great mix of people. I think the justice that we all thought was technically the most proficient lawyer was Harlan, the second Justice Harlan. I wasn't always inclined the way he voted, but nor was my justice, Justice Whitaker. Justice Whitaker is much more conservative than I was, but there was no question about who was boss. And you know, I was happy just to help him out. But I think Harlan, for being just a good lawyer's lawyer, was probably the model on that court. But there were other things that were really inspiring, like Warren, the chief, who wasn't technically, you know, oriented as a lawyer, but I got there just as the Little Rock case was being argued. There was a special argument in July. The court reconvened just for that argument. And they came out with, this is 4 years after Brown against Board of Education, and they came out with an opinion saying, yes, you know, you do indeed have to integrate Little Rock, and the chief got all the justices to actually sign the opinion. And when it came out, so the Little Rock opinion is signed by every justice, and to hold the court together that way and to have that kind of a unified statement about a very difficult process of desegregation was a great achievement. And in that sense, Warren was a marvelous model. Brennan, I think in later years, probably became the justice I admired the most in the later years after some of the others were gone. Justice Black was a very impressive person when I was there. But that was a great year.
It was really the judicial dream team in that era.
Yes.
These were great justices.
There were only 18 clerks. Each justice had 2 clerks, except Douglas always just had 1, and the chief had an extra clerk because he had more duties to take care of. But that made a small group, and so we worked all week, and then on Sunday mornings we played softball. And it was a great year.
So after you completed your time clerking on the court, you went into law practice.
Right. I came back to St. Paul, where I'd grown up, and when I was in law school, the Oppenheimer firm had approached me. A person we know in the family was in that firm, and he called me in senior year. So I went down to work for them for about a month before I went in the Air Force. And they expected me to come back, and I'd written them would it make sense to postpone my coming for a year while I have a clerkship? And they said yes. We certainly would still want you to come. So I joined a big law firm, the Oppenheimer law firm. It was a big law firm. I was the 11th lawyer. I think it's probably the second biggest firm in St. Paul. 9 of those lawyers were partners, and I was one of the 2 associates. And life was so different in those days. 9 partners cannot get rich overworking 2 associates and billing their time. The partners sold their own time and their own services. And as a consequence, although I kept track, nobody ever asked me how many hours I billed. I'm unaware of how many hours I billed. I know that 5.5 to 6 hours was a very good day because we didn't count phone calls, and we didn't, if somebody interrupted us to talk about a different case for 10 minutes or something, we didn't keep track of that because the bills were only kind of roughly related to the time put in anyway. And it was a different kind of practice, a wonderful practice. just great.
So you enjoyed practicing law,
Yeah.
just in the same way you enjoyed going to law school and clerking on the court, but then you left the practice of
I'll
law.
say. Well, I started getting more interested in the wider world. And Kennedy had gotten elected, and the new frontier was expanding, and I started looking for something having to do with foreign affairs. And I went down, I interviewed with the legal office of the State Department, AID, and looked around Washington a little bit. But then the Peace Corps was just starting, and so somebody said, well, go over and interview at the Peace Corps. And I did, and the Africa director seemed to like me or something, so he said, okay, we'll hire you and send you to Eastern Nigeria. So I went back and told my law firm that I was leaving to join the Peace Corps staff. I couldn't be a volunteer because by then we had 2 7/9 kids, and you couldn't have dependents and be a volunteer, but I could be a staff member. So I got some books out on Eastern Nigeria, and then about 3 weeks later they called and said, you're going to northern Ethiopia, Eritrea. So I took those books back to the library and found some on Ethiopia, and we went to Ethiopia as one of the very early Peace Corps projects, and that was the first big one. We went into Ethiopia with 300 volunteers. I had 78 under my wing up in the north. I was separated from the rest of the staff up in Asmara, which is now Eritrea, but was then part of Ethiopia. And it was a wonderful time again. I've been lucky all my life in getting into great situations, and one was the Peace Corps. In the earliest days, the countries in Africa were opening up and were very receptive. We're delighted to have the volunteers. The volunteers were young and idealistic, generally sort of generalist college graduates. Vietnam hadn't come along yet, so nobody was trying to find an alternative to military service or anything. They were as enthused about doing something expansive as I was, and it was just a great time.
Do you think you made an impact? Do you think talk a little bit about what you think the Peace Corps accomplished?
The biggest impact of the Peace Corps, and this may surprise you, is on the United States, because those volunteers came back. A very high degree of them went into some sort of public service-oriented work. The Peace Corps had a big impact on them, and many of them stayed active. Incidentally, in September, I'm going back to Ethiopia with a bunch of volunteers, probably close to 100 of them, to celebrate the 50th anniversary of our arrival, and the foreign ministry is going to throw a party for us, and we'll be in Ethiopia for a week, and the volunteers will go out to the villages where they taught 50 years ago, and so we're looking forward to that. And we've gotten all our immunizations last week.
That's good. Did that experience working in the Peace Corps change you in any way?
Well, it did. I didn't know if I was ever going to get back to law. I worked that first year in Asmara in the north of the Peace Corps, and then the deputy director of the project moved on, and I became deputy, so I had to move down to Addis Ababa, and my work was a little more administrative. And then I was made director of the new project in Uganda, so that was another 2 years. So I was about 4 years in Africa. But I think both my wife and I decided that you can't be an expatriate forever and be very comfortable if you kind of want to participate in the policy decisions of a country, because you can't get involved in the politics of the host country you're in. You're not a citizen and you don't want to interfere in their affairs. But you want to have something to do with your own country's affairs, and it's hard to do that if you're permanent expatriates. So I think we thought we needed to come back. Meanwhile, my classmate, when I was in law school, I got to be very friendly with a very idealistic young classmate named Walter Mondale. And I got married after the first year of law school, and that summer, my wife and I managed to get him a blind date with my wife's sister, and so they got married. When I was in law practice, I had been treasurer for Mondale's statewide campaign, first statewide campaign for Attorney General. I was treasurer of that campaign. The whole campaign cost $7,500. And life was different in those days.
Sure.
And that was mostly radio spots. But when I got back from Uganda, Mondale was again running, this time for the Senate, and he was already in the Senate. He'd been appointed to fill Humphrey's seat, but he had to run. And he asked me to come and work in his campaign. So I did that for 8 months or so, up until the election, as a speechwriter, and worked in his Senate office. Then, right after the election, I decided I'd like to get back into law, but I'd like to try teaching. So I looked around, and Willard Pedrick came to interview me at my house in Washington. He was the newly appointed dean of a new law school, and I thought it'd be fun to start a new law school. So he hired me, and I knew that next July I would go to work at Arizona State. But I had from January 1st to July to stay on some payroll, so I went to work for my former boss in Ethiopia, Harris Wofford, who was starting a new college at State University in New York at Old Westbury. So I kind of commuted from Washington up there and served as his special assistant while we planned a college. But then in July I came to Arizona State. The faculty were essentially 5 that first year, because we only had a first-year class. I was the only neophyte. Pedrick recruited really seasoned, well-known people. So I was the flyer he took. But there again, a new law school. Well, what would you like to teach? Well, how about constitutional law and conflicts? They're yours. Well, great. So I started teaching constitutional law and conflicts. After 3 years, I took a leave of absence and went back as a Fulbright professor and taught for a year in Uganda. When I was overseas, I wrote a letter to Pedrick saying, if to recruit new faculty you need to offer conflicts, feel free to do that, because I don't have to keep hold of that. I sure do want constitutional law, though. I had said at the law school I'd once threatened to write a conflicts exam saying, take one side or the other of the following proposition and write an essay. Resolved that if every conflicts case decided in the last 10 years had been decided the other way, it wouldn't make any difference. I was spoiled by constitutional law, because it makes a big difference how those cases are decided.
Sure. So at some point you became interested in Native American law.
I did, and that was interesting too, because when Pedrick hired me, he said, I know I've been there a year organizing and trying to set up the law school, and I need to take a vacation. I'd like to take it in July. Could you come early and for the month of July act as acting dean, just, probably without the title, just, run the office for me. And I'd been there a couple weeks, and a guy came in from what was then called the Law and Order Division of the regional office of the Bureau of Indian Affairs. And he said he wanted to bring tribal judges into Phoenix 1 day a month and put them in a motel in Phoenix and have somebody teach them just sort of basic evidence and things like that? Well, I've been interested in local law and things like that in Uganda, just seeing the traditional courts and things like that. I thought that would be very interesting, so I said, "Oh, sure, I'll do it." And then as we got a class, I talked to one or two people who were actually teaching Indian law. There weren't many. And decided when we had a third-year class, I'd put together some materials, and so I did, mimeographing materials and drawing cases. And so I started teaching Indian law. Then the West Publishing man, sort of a missionary man, would come out every year, and he'd stop by and he said, "Why don't you write a nutshell on Indian law?" And I said, "Well, there's not enough demand. There are only 2 or 3 Indian law classes in the country, and they needed to sell 3,500 books to make it worthwhile." And I said, no. So I said no for about the 13 years that I was teaching. And then the last year I said, "Okay, I'll do it. There are enough Indian law courses now. I'll write a nutshell for you." And of course it's half written. And I get appointed to the Ninth Circuit. So my first several months on the court, I was doing judicial work all day, and at night and weekends I was finishing the nutshell on Indian law. And that came out. It's now in its 5th edition, and they'll want another one next year, and so I'll bring it up to date.
Yeah.
But that's been, when people meet me and know anything about my academic career, they always say, "Well, you're the Indian law person." But actually in teaching, I taught much more constitutional law than I did Indian law, and I probably had more fun doing it. But Indian law is very interesting, and I keep an interest in it. And there again, luck, I get appointed to the Ninth Circuit. It's got more Indian law than any other place in the country.
Sure. So talk a little bit about your nomination to the court, the confirmation process. How did that all go?
It was interesting because Carter, for the first time, decided he was going to have merit commissions instead of just sort of asking the senator to go ahead and appoint somebody. And with the merit commissions, you could simply apply. It was considered probably more seemly if somebody would suggest your name, so that Pedrick suggested my name to the commission. I went through the commission twice. I wasn't appointed either time. I was on the short list both times. But the first one went through, and Tom Tang was appointed. He had been a law clerk for Senator Dennis D. Cassini's father when he was, and I wasn't surprised when Tom, wonderful person, got appointed. And then we had another round about a year later, because the Ninth Circuit, at the time Carter was having these commissions, had expanded by 10 spots. A 13-judge court expanded to 23 judges, active judges. So there was another commission, and 3 names were sent forward, and one was Mary Schroeder, and one was myself, and there was a third one. And Mary got it, and that didn't surprise me. I thought, fine, I'm enjoying teaching, and I was on the short list both times. That was very nice. And then, to my surprise, Ozell Trask took senior status. I didn't know that was going to be, because the two additional slots that were allocated to Arizona had been filled in those first 2 rounds. The Justice Department told Senator D. Cassini that we can do another round in the merit commissions, or you can take somebody who was on the previous list, because it's only been about 6 months or so since that happened. So he called me up and said, "You're it." And I was nominated in late October, had my committee hearing in late March, was confirmed in May, got commissioned in May, and sworn in on July 3rd because DeConcini wanted to be back in Arizona for the swearing in, so I waited until then to get sworn in. And DeConcini was essentially the person who appointed me. But it was an interesting process. The merit commissions, Carter couldn't succeed in doing that with the district judges. There was too much of an uproar from the senators. Senators are much more concerned about who's going to be a district judge, because an Arizona senator, for instance, appoints me, and then I spend most of my life dealing with cases from California or Washington or Idaho or Montana, and only some from Arizona. So I don't affect the life of the state nearly as much as a district court, Arizona district court appointment. So the senators did not want merit commissions for those. They just wanted to make their appointments.
Sure.
But they were willing to do it for the circuit. So that's the way I came on the court.
Okay. Talk a little bit.
Confirmation was all of an hour.
So
the hearing
times have changed.
Yeah. I couldn't get confirmed today, I don't think. I was on the board of Right to Choose in Arizona. Imagine the opposition. There's no way.
Sure.
Under the present climate, I don't think I could possibly get confirmed.
Sure. So talk a little about what it was like when you first became a judge. You first put on the robes. How did that feel?
You know, it felt good, and people said, I don't remember, and I don't think I ever did, go to the baby judges school or anything, that a few days that you go off to. I never did that. But if there's anything law school teaches you how to be, it's an appellate judge. You know, we may know nothing about how to practice law when we get out of law school, but we've been dealing with appellate cases, and only appellate cases in those days. Plus the clerkship. I mean, I knew quite a lot about the business of how an appellate court works. But, so I don't think I felt daunted, but it was still, it was really impressive to, put on the robe and go to, my first sittings were in San Francisco. They said, why don't you sit for a couple days before the circuit conference so you'll kind of have a context for what you can come to the conference and see what we're talking about, and you'll have a little experience. So I sat 2 days with, and the presiding judge was Ben Dunaway, and that was a great introduction. Ben Dunaway was a great judge, terrific, and having a couple days with him was a very good introduction. My first full calendar then was September, and as I said, I was sworn in July. I had those 2 days with Dunaway in August, and then in September I went on a full calendar to Portland. One of my very early calendars was in Los Angeles, and we used to sit at the top floor of the Spring Street courthouse. And I got up into the robing room, and there's a table there, and there's a notice taped to the table, and it said, "Do not move this table. If this table needs to be moved, call the marshal first." And then I saw that, well, there's a wire leading down the table or something, and I suppose there was a panic button. When I got on the bench, each seat had one of these, a little button you could push in case of emergency. Well, Arthur Alarcon was presiding, and I leaned back in my chair, and the springs weren't at all tight, and it went back. And I grabbed like this, and I said, did I hit that button? And I didn't, so, I came forward, and we were hearing an argument and everything, and pretty soon, a couple of great big guys walked into the back of the courtroom, with suits on, and they're looking around and everything. And Arthur stops the argument and says, just a moment, you gentlemen can take seats up here if you want. And they said, well, we came because there was an alarm from here. And I sent a note to Arthur saying, I may have hit the button by accident. And so Arthur says, well, that's false alarm, go ahead, everything's all right, you can go on. And we went on with the argument, but Arthur passed a note to me saying, damn new kid on the block. And so I wrote him a note back saying, I only pushed the panic button because I had a horrible feeling that someone was moving the table in the robing room.
So you mentioned Judge Alarcon, Dunaway. You've served with some tremendous jurists.
Yeah.
Any you want to mention a few that really have stood out, really have influenced you as maybe as a jurist, as a man?
Yeah. Well, as I said, I've been lucky all my life, and one of the greatest examples of my luck was that I was appointed to this court when Jim Browning was chief, and he was chief for many years after I got on the court. He was absolutely fabulous. He could take the most contentious situation, and he had a very warm, soothing voice, and he's just the soul of reason, and he exuded the idea that reasonable people can handle this, and this is what, how to, now consider this and consider that, and he could, it was just wonderful. As a court leader, he was marvelous, and he was chief for many years after I came, and he was definitely the guiding light. But others that were there when I came on the court, Ben Dunaway, I've already mentioned, he was terrific, and so was Charlie Merrill, who was on the court from Nevada. It was very good coming on the court when Jim was there. The court was expanding, and we went from 13 to 23 judges, and I'm sure that was a shock to the existing judges, because all of a sudden you've got a new majority basically.
Sure.
Carter got, with normal attrition, something like 13 appointments to a 23-judge court. That legacy lasted for quite a while, because that's 13 Carter appointees. It means a majority of our court. But Carter got no Supreme Court appointments. The Supreme Court wasn't necessarily in sync with the Ninth Circuit for years after. Maybe never has been.
Well, and so you've served on the court. You've heard a lot of important cases. Any cases, any decisions in particular that stand out in your mind? Cases that you found particularly difficult? Cases that you are especially proud to have participated in?
Well, one, Pruitt against Cheney, was one that was a woman who had been, she was about to be promoted to major and had been discharged because there had been an article written in which she admitted being a lesbian, and her case was thrown out by the district court, and we reversed it and said the Army took the position that the complaint was insufficient on its face, that you couldn't challenge. That the Army didn't have to prove a rational basis for this or anything. And we said, yes, it does. You've got to explain why they're doing this. And the antagonism of some people toward homosexuals is not a rational basis. So send it back, let them amend and state an equal protection claim, let the Army come in and try to justify this. It settled after we did that. But that case followed on Watkins against U.S. Army, which was a case, a guy had been a sergeant in the Army for 18 years and he's getting close to retirement. And he had said on one or two re-enlistments, he said, well, I am gay. And they said, that doesn't make any difference. It was a time when they needed soldiers and stuff. And then he gets 18 years in and they say, well, no, we're going to discharge you because you're gay. And I was on a panel, I didn't write the opinion, that upheld his claim. It went in bank, and I joined an opinion written by Judge Norris, who had written the panel decision, the three-judge decision, saying, well, it just violates equal protection. Heck with it. But the majority went on estoppel. They said the Army, in accepting his reenlistment, knowing he was gay,
Sure.
It was estoppel, and I thought that was an important case. And I think my dissent from the denial of in-bank review and high-tech gays was pretty much states my view on gay legal rights of gays and lesbians. And I would have made it a suspect category for equal protection purposes, which would be fatal to almost any adverse classification
Sure.
against gays, lesbians,
Sure.
and transsexuals. Another case that occupied a lot of my effort in the last few years is a case I lost in the Supreme Court. The first case the Supreme Court decided this year wasn't argued. It was a summary reversal of an opinion I'd written, and it was Smith against Cavazos, and it's a shaken baby case. A woman had been convicted in state court, a grandmother taking care of 3 kids. A 7-week-old kid dies, the mother's in the next room, the other 2 kids are sleeping. And at first they thought it was just sudden infant death syndrome, and then they found there was some blood on the brain, not enough to cause death. So the state pathologist says, well, it's a shaken baby case, and so testifies. They said, well, there are no bruises. I mean, this is a grandmother who everybody said had been a loving caretaker. The mother's sleeping in the next room. The 2 other kids are sleeping there. Nobody wakes up. There's no crying. Just death in the middle of the night. And the state pathologist said, well, it's true that, yes, there's no detached retina, there's no bruising, there are no broken ribs, there's nothing, except our theory is the shaking was so violent it sheared the brainstem and caused instant death with no bruising and no bleeding in the brain, and that can't be detected in the brain because death was so instantaneous. There was no swelling, no bruising, nothing. I mean, I don't think there's ever been a shaken baby case. Well, she was convicted. It's 15 years to life. She's 55 years old at the time of the death. And we get the case. She's been in prison 8 years. And we said no rational jury could accept this evidence. Even though there was expert testimony saying it was shaken baby, the experts had nothing to substantiate their opinion. And the state took cert, and the Supreme Court vacated and reversed for reconsideration in light of one of their recent cases that had reiterated that there's huge deference due to the jury, and under AEDPA and under deference to state courts and deference to fact-finding and everything. So we reconsidered and said, well, that's the standard we applied. We said right in our first opinion that we understand the huge deference that's owed and so on. So we reinstated our original opinion, and incidentally, we did not stay our mandate ever along the line, and the Supreme Court didn't interfere with that. So she was out during this time. It went back to the Supreme Court, and they vacated and reversed again and said reconsider in the light of another case, and we reconsidered in the light of another case and reinstated our original opinion. And then the Supreme Court, in its first opinion this year, angrily reversed and said we've done just exactly what we're not supposed to do, and so on. And there's a vigorous dissent by Justice Ginsburg with Justices Breyer and Sotomayor, saying that this was a bad case. She since had her sentence commuted to time served by the governor of California. Through the efforts of a lot of people.
Right. So, Judge Canby, I've asked you a lot of questions about various stages in your career. You've done an awful lot. You've been a practicing lawyer, a law clerk, a professor, obviously a judge. Is there anything I haven't asked you that you'd like us to record?
No, I think you've summed it up. I've had the two best jobs in law, being a constitutional law professor and being a circuit judge. Really, they're two of the best jobs the legal profession has to offer. And I wouldn't do that any differently. My wife and I say, though, if somebody were to peel away our past and take it away from us, the last thing we let go of would be the Peace Corps years.
That's great. Judge Canby, it's been a real pleasure. Thank you.
Good. Thank you.